the treatment of interns under the Fair Labor Standards Act. And if you've been following this area at all, you'll remember that there was litigation involving interns who worked on the Black Swan movie project. There was class action. There have been other class actions involving interns. So it's a fairly live issue at this point. And it's another one where the change in administration is leading to a change in the standards at the Department of Labor. So when I say intern, what I'm talking about is someone who is brought on by a company to work, but the idea behind the work is that the intern will also be learning things as part of the work process. It's something that's very familiar to the entertainment industry, but there are plenty of other employers who have interns. And the issue under the Fair Labor Standards Act is whether the person is an employee or not. Now, unfortunately, for clarity in this area, the Fair Labor Standards Act itself is very unenlightening. So what the statute says is that the Fair Labor Standards Act minimum wage and overtime requirements apply to employees. And the definition of employee under the Fair Labor Standards Act is an individual employed by an employer. Employ is defined in the Fair Labor Standards Act as to suffer or permit to work. So we've got a very vague definition all around there, and we've been left to court decisions and Fair Labor Standards Act interpretations and regulations to have a full understanding of what we mean by employee as opposed to something else who is an intern and therefore not covered by the Act. So up until recently, the Department of Labor had not a regulation, but a fact sheet. I've given you the full fact sheet on page 48 and 49 of your materials about the treatment of internship programs under the Fair Labor Standards Act. That was a 6-factor test, and I've got the 6 factors here on the slide. And under this test, the program that the intern was doing work in had to meet all of the criteria. So if we have these 6 under the old Department of Labor standard, then there's no employment relationship. So the training had to be similar to what is expected in the educational environment. The program had to be for the benefit of the intern. There had to be no displacement of regular employees. There could be no advantage to the employer from the arrangement. There could be no assurance to the intern that he or she would be entitled to a job at the end of the program. And there had to be a mutual understanding between the intern and the employer that there would be no pay. So that was the standard that had been in place for several years under the prior Department of Labor. Now, as I mentioned, there has been a significant amount of litigation over the past few years regarding the status of interns and whether they are entitled to overtime and minimum wage under the Fair Labor Standards Act. One of those is the this Black Swan litigation, which is a class action that grew out of the use of interns by Fox Pictures in the movie industry. So what happened there was that a couple of interns who had worked on the Black Swan production were not paid, and they brought an action on their own behalf and on behalf of a class of interns, alleging that they were actually employees and they should have been paid overtime and minimum wage and not been uncompensated. In that case, and we'll look at the case itself a little bit more detail in a minute, the Second Circuit Court of Appeals in New York rejected the six-factor Department of Labor test, the one that you have on your screen right now, and went back to a much earlier U.S. Supreme Court case and a more flexible analysis. So and that standard we call the primary beneficiary test. So it's a test that looks at 7 factors, none of which is determinative. So, and under this test, we look at whether there's an expectation of compensation, how much training is provided, whether or not the internship program is tied to some formal education program, whether the internship program accommodates the intern's academic commitments, whether the internship is limited to the period when the intern is actually learning something. It complements the work of paid employees rather than taking the place, and whether or not there's an entitlement to a paid job at the conclusion of the work. Now, as a result of relooking at this issue, the Department of Labor published a new fact sheet number 71 in January this month, which of course took place after I put together your materials. So if you go to the Department of Labor website, which is www.dol.gov, and search for fact sheet number 71, you should pop up the new fact sheet. And I will just describe to you what it says, and then I want to look in a little more detail at the Black Swan litigation so we can see the real world implications of the change in standards. So what the fact sheet says is that interns and students may not be employees under the Fair Labor Standards Act, and therefore the Fair Labor Standards Act doesn't require compensation, but we need to look at who the primary beneficiary is. Courts have used the primary beneficiary test to determine whether an intern or student is in fact an employee under the Fair Labor Standards Act. In short, this test allows courts to examine the economic reality of the intern-employer relationship to determine which party is the primary beneficiary of the relationships. Courts have identified the following 7 factors, and those are the factors that I have listed on your screen. Probably there's more to come as the courts and the Department of Labor deals with the implications of the primary beneficiary test. But for right now, that's what the fact sheet says. Now, it also points out a distinction between a student or intern and a volunteer. So a student or intern is somebody who is providing services without compensation in the expectation of getting some training or educational benefit out of it. That's what makes somebody a student or intern, but not an employee. Now, the Fair Labor Standards Act does recognize that there are people who volunteer to provide services with no expectation of being paid, and they are not considered employees under the Fair Labor Standards Act. However, such volunteers are not permitted to provide services for-profit companies without receiving compensation. So the Fair Labor Standards Act exempts people who volunteer to perform services for state or local government agencies, or who volunteer for humanitarian purpose for food banks. And then the Department of Labor's Wage and Hour Division has extended that to include individuals who volunteer their time freely and without anticipation of compensation for religious, charitable, civic, or humanitarian purposes to nonprofit organizations. In those circumstances, unpaid interns could be treated as volunteers, but for-profit companies cannot use volunteers, and therefore whether or not their interns are employees is determined by looking at this 7-factor primary beneficiary test. Now, I said I wanted to look at the Black Swan litigation in a little more detail so we can see how the test plays out in the real world. And I've given you the decision from the Second Circuit that I mentioned earlier. It starts on page 51 of your written materials. And what I want to do first is to look at the circumstances under which the interns who brought the class action lawsuit were providing services. So, as I mentioned, the two named plaintiffs had been unpaid interns for Fox Searchlight, and it's the production company that produced Black Swan. One of them already had a degree, an undergraduate degree in multimedia instructional design, but he was enrolled in a graduate program at NYU's School of Education. That program did not offer him credit for his internship, but you can see that he begins to fit into the internship category because he's still involved in education, and it could be said that he's looking to his work for Fox Searchlight as an extension of the training that he was receiving at NYU. He worked in the accounting department, worked long hours, 9 to 7, 5 days a week. He had responsibilities for copying, scanning, filing documents, tracking purchase orders, so on and so forth, all sorts of things which are definitely going to be to the benefit of the employer. So those sorts of things would push the primary beneficiary analysis towards the employee side of things. The internship is somewhat tied to formal education. It doesn't sound like his academic commitments are being accommodated if he's working 9 to 7, 5 days a week. And rather than complementing the work of paid employees, it might be argued that he was actually performing work that if he weren't there, paid employees might be performing. The other named plaintiff had a degree in film studies, but at the time that he was interning on Black Swan, he was not enrolled in a degree program at all. He worked in the production department, worked 10-hour days, 5 days a week, and during this time he picked up and set up office furniture, arranged lodging for cast and crew, took out the trash, took lunch orders, answered phone calls, made watermarks on the scripts, drafted daily call sheets, and so on and so forth. All things that sound like they were essential to the work of putting that movie together. So what happened in the lower court was that the named plaintiffs had asked the lower court to rule in their favor with respect to their status as employees, and the lower court agreed. So the district court in New York had ruled as a matter of law that they were employees and that they were entitled to serve as class representatives for a class of all interns who had worked for Fox Searchlight during a set period of time. On appeal, as I mentioned earlier, and the district court had relied on the Department of Labor test in part in determining that the plaintiffs were employees of Fox Searchlight. Depart a little bit, but primarily relied on the six-factor test. So when it gets to the appellate court, the Second Circuit says, well, that test is really not appropriate. And it goes back to a case that the United States Supreme Court had decided in 1947. In that case, the question was whether railroad brakemen who were being trained in their jobs were employees or not. And the Supreme Court had ruled that they were not. And in doing so, it looked in particular at the fact that they didn't displace regular employees because they weren't ready to perform the task of brakemen. So they were just being schooled in how brakemen did their jobs. They didn't expect to receive any compensation. There was no assurance that they would be hired at the completion of the course. It was similar, the training that they received as brakemen was similar to what they would have gotten if they'd gone to a vocational school. And because the employer was primarily interested in training them for the jobs rather than actually getting work out of them, the employer did not receive any immediate advantage from it. So that we know from the Supreme Court is the rule under the Fair Labor Standards Act. And then what had happened is that the Department of Labor took that case and developed from it the six-factor test that's in the worksheet that has been supplanted this much, the fact sheet that's been supplanted this much by the new one. So the Second Circuit said it's not an appropriate way to go. We need to get back to the more flexible approach that the Supreme Court had taken in its 1947 decision. And then they explain why it is appropriate for some interns to be treated as employees and some to be treated and some not to be treated as employees. So they say, if you look at page 61, when properly designed, internships are widely supported by educators and by employers looking to hire well-trained recent graduates. However, employers can also exploit unpaid interns by using their free labor without providing them with an appreciable benefit in education or experience. Recognizing this concern, all parties agree that there are circumstances in which someone who is labeled an unpaid intern is actually an employee entitled to compensation under the FLSA. All parties also agree that there are circumstances in which unpaid interns are not employees under the FLSA. They do not agree on what those circumstances are. And then the court goes on to, the Department of Labor came into the case as what's called a friend of the court, advocating its view that was set forth in the prior fact sheet. because this litigation was going on a couple of years ago. But the Second Circuit rejected that, and they said, we agree that the proper question is whether the intern or the employer is the primary beneficiary of the relationship. That has three important features. First, it focuses on what the intern receives in exchange for his or her work. And that's like what the Supreme Court had looked at in that 1947 case. It accords courts the flexibility to examine the economic reality of the relationship between the intern and the employer. And finally, it acknowledges that the relationship should be analyzed the same way that we analyze other employer-employee relationships. So it's good in that sense for employers. There's more flexibility. But on the other hand, it is difficult to tell in close cases which way you're going to come out. The one benefit that employers had from the previous approach is that they knew where they stood. You either could satisfy the 6 conditions of the prior fact sheet or you couldn't. Now we have to look at these 7 factors. The Second Circuit called it a non-exhaustive set of considerations, and it will requiring weighing and balancing all of them in each case. No one factor is dispositive. Every factor need not point in the same direction for a court to conclude that the intern is not an employee. And if the decision recognizes that courts may identify some other factors that should be considered in future cases. And then it concludes by saying, the approach we adopt also reflects a central feature of the modern internship, the relationship between the internship and the intern's formal education, and is confined to internships and does not apply to training programs in other contexts. The purpose of a bona fide internship is to integrate classroom learning with practical skill development in a real-world setting. And unlike the break-minute issue in the earlier Supreme Court case, all of the plaintiffs were enrolled in or had recently completed a formal course of post-secondary education. By focusing on the educational aspects of the internship, our approach better reflects the role of internships in today's economy than the DOL factors, which were derived from a 68-year-old Supreme Court decision that dealt with a single training course offered to prospective railroad brakemen. Now, the reason that I have spent some time on this case is that its approach has been adopted by other federal courts of appeals, and it has been recognized in this new fact sheet that I referred you to earlier. So it is the best expression of the standard that we're going to be using over the next several years to determine whether we have a true internship or we have a relationship in which the intern should be treated as an employee and entitled to overtime and minimum wage. Now again, the question of who's an employee or not under the wage and hour rules is one that may vary depending upon your jurisdiction. And we have, for example, we have in California a more expansive definition of employ than we have under the Fair Labor Standards Act. So it's quite possible that a state court in California could rule that an intern like the ones who brought the Black Swan litigation was an employee, whereas a federal court applying the Fair Labor Standards Act might conclude that the intern was in fact an intern, not an employee, and not entitled to the protections of the Fair Labor Standards Act. So what happened with the Black Swan litigation is that the ruling in favor of the interns was reversed by the Court of Appeals and the case went back, but not necessarily the decision doesn't say that they definitely are interns and not employees. It says that the lower court has to reevaluate the case in light of the primary beneficiary doctrine. The case then settled, so we don't have a final determination as to whether the interns in the circumstances described in the case are employees or not under the Fair Labor Standards